Please, Lord, please. I'll be confined only, my Lord, obviously to the question. I'll be confined only, my Lord, or which your lordships have assembled. For which your lordships have assembled.
Retrospectivity or prospectivity?
My submissions are, my Lord, following. Lord, my submissions are, my Lord,
India
following.
Cements
have held the field since
India
35
Cements
have
years,
held the field
and
since
parties have
35
bona fide
years
under the
and
law
parties have
applicable
bona
at the
fide
relevant point of
under the
time,
law applicable
adjusted their
at the
affairs
relevant point of time
accordingly. Adjusted their affairs accordingly.
Yes. Well, the difficulty with the mineral sector is this. Well, the difficulty with the mineral sector is this.
Essentially used
Mineral
in
is
every
essentially
core
used,
sector of the
Lord,
economy.
in every
Core
it
sector
will
of the
have
economy.
direct impact on the economy of the
will
nation.
have
We are not,
direct
Lord,
impact
on the
on
economy of the
individuals or
nation. We are
companies
not,
or
Lord,
on
individual
individuals
states,
or
core
companies
or individual states. Lord,
core industrial sector, my lord, especially industrial
critical
sector,
to
my lord,
infrastructure
especially
sector, my Lord.
critical to infrastructure sector, my lord.
Almost all industries,
I'm sorry.
almost all industries,
Directly
or indirectly, are dependent on
Directly
minerals.
or indirectly,
For example, my lord, are dependent
steel,
on
you
minerals.
need
For
iron
example,
ore.
my lord, for
For
aluminium,
steel,
you need
iron
bauxite.
ore.
For generation of electricity,
bauxite.
my lord, almost
generation of
68%
electricity,
my lord,
generation,
almost is through coal, which is again a mineral.
generation.
Is through coal, which is again a mineral.
Yes. Now, industries, whether it is public sector or
Now,
private,
industries,
cannot
whether it is
absorb
public
the
sector or
sudden
private,
rise, cannot absorb the
of
sudden
past,
rise
years
of
Lord,
past
itself. It will have to pass
years,
it on. Lord, itself.
it will have to pass it on.
Now, kindly, my Lord, allow me to give an example of electricity.
Allow me to give an example of
coal had a
electricity.
particular price.
My lord,
Electricity,
the coal
at
had
the
a particular price.
prevailing
My lord,
law
it
at
was
the price
given
at
point
the
of time.
prevailing
Based
law
upon
at the
which given point of
respective
time.
commissions have
Based
framed
upon
their
which
tariff.
the respective
Based
commissions
upon
have
which the
framed their
consumers have
tariff.
paid.
Based upon which the consumers have paid.
Now, my Lord, the serious question now would be,
Now,
now,
the serious
Lord,
question
suppose
now
the
would be,
generating company
now,
or the distribution
suppose
company
the
or any
generating
company
company
concerned
or
with
the
the distribution
generation
company
or
any company
transmission of
concerned with
electricity
the
using
generation
minerals,
or transmission
were
of
to
electricity
pass on,
using
minerals,
Lord, this
were to pass on
additional past
Lord,
burden,
can it be
additional
passed
past
on to
burden,
new consumers?
can it be passed on to new consumers?
Because all old consumers, my lord, have gone. They have paid respective
old
charges
consumers,
as
my
per
lord, have
law.
gone. They have paid
And,
respective
Lord,
charges
now
as per
we
law.
can't
And
ask
them
now
to make
we
the
can't
payment.
ask them to make the payment.
Lord, the moment electricity is affected, Lord, the
And
moment
electricity is
the
affected,
basic
and
input,
the moment,
like
my
Lord,
lord, the
bauxite or
basic
input,
iron
like
ore,
Lord,
etc.
bauxite
is
or
impacted. Lord, iron ore,
necessarily
etc.
it
is
will have a
impacted.
cascading effect.
Lord,
And the
necessarily it
effect
will
have a
be-
cascading effect.
And the effect
Felt
will be
actually
by
felt
the common man.
actually
By the common man.
Lord, now, Lord, there are several domestic contracts. Lord, now, Lord,
Entered
there are
into
several domestic
several
contracts
international contracts
entered into,
several
based
international
upon the law
contracts entered
prevailing
into,
then.
based
And
upon the law
every
prevailing
contracting
then. Party was
And
justified. Every contracting party was justified. Lord, in choosing their commercial bargain, Lord, in
based upon the
choosing
law
their commercial
prevailing
bargain, Lord,
based upon the law prevailing
national
then,
contracts, your
Lord,
lordships are aware,
international
some of the
contracts as
national
such,
contracts, your
where
lordships are
one of
aware,
the
some of the
contracting
contracts
parties
as such,
always
where one of the
wanting a way
contracting
out
parties
of
always
wriggling
wanting
out
a
of the
way out
contractual
of
obligations.
wriggling
We will
out
use
of
this
the
Malord
contractual
now,
An
obligations.
additional
We will
burden now
use
the
this Malord
financials have
now.
changed. An additional burden now the financials have changed. And they will cite, my lord, if there is a provision, my lord, in the contract for change in law, provision, my lord, in the contract for change in law, no such provision, they will not be able to cite it, they will find out some other way, then now able to cite it, not commercially viable for us, now it's continue with the contract, not commercially viable for us to continue with the contract, and would lead to multiplicity of, and would lead to multiplicity of, which we are unable to, my lord, litigations comprehend at this juncture, my lord, comprehend at this juncture. Commercial contracts and commercial treaties, domestically and internationally, would be impacted. In every industrial, I'm sorry, my lord. The burden would eventually go to the common man. The burden would eventually go to the common man. He will be the person directly or indirectly, because no industry can absorb. Because, for example, we made a rough estimate. For example, public sector rough estimate. Only this is rough and ready, my lord. It is still the process. This is rough and ready, my lord. It is still the process of approximate demand, which the only approximate demand expecting only would be somewhere in the vicinity of 70,000. Would be somewhere in the vicinity of 70,000 to 80,000 crore.
Now, Mr. Solicitor, what was the prevailing interim arrangement during the pendency of these matters?
There are several categories of cases. There are in some cases the state government, in some cases the High Court, state government, the order, the High Court quashed the order legislation of the state legislation of the state government, like Orissa, and there is no stay, and they have never raised any. There is no stay, and they have never raised any
for
demand.
35 years.
For 35 years. In some, there may be some, either, my lord, there may be some, either, my lord, your lordships may not have granted stay. The law was upheld, so some have paid. May not have granted stay, so some have paid. Some may have paid under the interim order of the court. Some may have paid under the interim order of the court. My lord, just I don't, I'll not name the PSU because I'll not name the company, my lord, in the stock exchange. But in one of the, my lord, in the stock exchange, public sector undertakings, the potential demand which we have calculated, the potential demand which we have calculated, net worth of the company is 3 times the net worth of the company. Not for obvious reasons, your lordships would know, my lord, I am not for naming obvious reasons, your lordships would know, my lord, Maharatna naming that PSU, but good, Maharatna sustaining, successful and financially fully viable, successful, ongoing, and financially fully viable, ongoing public sector undertaking. This would be the position with many public sector undertakings. This would be the position with perhaps many public sector undertakings. Most of the industries, perhaps, my lord, if they have to absorb. Most of the industries, my lord, if they have to absorb.
Repeatedly points we have understood. Now we have to go by also. Now we have to go by also. So what was the interim position for all these years? So what was the interim position for all these years? The High Court has quashed the legislation. And there is no stay the legislation by this court. And there is no stay granted by this court.
I have a suggestion.
There is no stay granted by this court.
I have a suggestion.
Where the law was upheld.
Only Bengal is the only example. Only Bengal is the only example.
Bengal is the only example of. Right. Yes,
Lord, what I am suggesting is, right, Lord, subject to appealing to your lordship's, I am suggesting, Lord, subject to appealing to your lordship's, as your lordship have said, my lord, ultimately, as your lordship under 142, a part of under 142 statesmanship. What I am suggesting is statesmanship. Lord, what I am suggesting is,
states do need revenue and funds.
Certainly,
states do need revenue and funds.
Certainly,
Nagaratna also mentioned in a judgment where Sister Nagaratna also mentioned in a judgment where Parliament actually validated the levy. So that was also the intent of validated the levy.
That was, my lord, in 90s. But we are, Lord, after 90s. Lord, what we are, Lord, after 90s. Lord, what suggestion I am, We may not go into the state-wise enactment. We may not go into the state-wise enactment and what happened. In some states, one or two states, in some states, one or two states, the amount may have been paid because of the your lordships to the no interim order passed by your lordships. Your lordships may consider. Neither may consider may demand any further. Neither the state may demand any further, nor retrospectively. Private parties or PSUs who have paid. Private parties or PSUs who have paid would seek any refund of the money.
Just one second, let me just.
This balances equities on both sides. This balances equities on both sides. I'm sorry, my apologies to you.
So suggesting there should be neither demand nor refund.
Nor refund, yes, but equity.
Nor refund.
Nor refund, yes, but equity.
Prospective subject to the condition, that whatever has been paid will not be
Will not be demanded as a refund by anyone. Will not be demanded as a refund by anyone, by the private parties who have paid.
It can't be refunded anyway because they have succeeded now. But what you are saying, we get the point that no recovery. What you are saying, we get the point that and no recovery, whatever has been paid under the interim orders will rest where it has been paid under the interim orders will rest where it has been paid.
Another worrying factor would be this. Your lordships are aware in MMDRA we had an amendment in 2000. We had an amendment in 2000. The regime of where auctioning, regime of auctioning, auction. While the participating bidders also not calculated the price bidders also not calculated the price point of time, and the law prevailing genuinely apprehend time and several litigations. Genuinely apprehend several litigations on that front.
What you're saying is that, well, to bring finality and what you're saying is that, well, to bring finality and some certainty in industry, we should really ensure that there is no further litigation. We should really ensure that there is no further litigation.
That's the respect.
And adopt a gold standard. Adopt a gold standard, which will ensure now there was an uncertainty in the law for 35 years. There was an uncertainty in the law for 35 years. Of course, Kesharam didn't operate only in the context of West Bengal. Kesharam didn't operate only in the context of West Bengal.
But nonetheless, needs wants to say something. But India Cement wants to say something. But Kesharam is 5 judges. It did not and could not. Kesharam is 5 judges. It did not and could not overrule. Ultimately, the I'm not saying that it was not. It was. I'm not saying that it was not. It was right. Even if we go back Kesharam 20 years, even if we go back Kesharam 20 years, have passed. Kesharam is 2004. Kesharam is 2004.
Now the matter is now the matter is eventually the conclusion of
But Kesharam is also 2004. But Kesharam is also 2004. When your lordships, when your lordships, would your lordships consider, would your lordships consider, I have cited some 50 judgments, in my note. I have cited some 50 judgments, in my note. My note contains, my note is circulated. No, note is circulated. I'll just followed, I'll just followed,
page 12 of your compilation.
One is synthetic chemicals. One is synthetic chemicals, inter alia. These are the two, I can immediately cite. Inter alia. These are the 90 volume 1 SIC, 109 volume 1 SCC, 1097 is Somaiya Organics, that is both are constitution bench. In my note, your lordships would find it at page. In my note, your lordships would find it at page. My para is my para is in synthetics chemicals. I have quoted the relevant. In synthetics chemicals, I have quoted the relevant, which is quoted by in my compilation. Which is quoted by in my compilation at Somaiya 2001. Somaiya is 2001 5 SCC 519. Synthetics is 7 judge bench. Somaiya is 5 judge bench, 7 judge bench, and Somaiya is 5 judge bench. Para page 51, there 59, para page 51, I have quoted all the relevant. 259, I have quoted all the relevant. Para 27, para 27.
We are well settled.
And when 2 to 27, I'll when 2 to 27, I'll
Let me look at now. Investment. Investment.
Yes.
Immediately followed,
it would have, my lord,
immediately followed,
would have, my lord, not only domestic, my lord, on the economic impact, my lord, on the.
I'll take 5 minutes.
Yes, the attorney has it, sir. Yeah, but broadly, I should be solicitor. We don't start doing. But broadly, I should be solicitor. We don't start doing anything more broadly. Here the you can tell us what the broad here the
impact on many
multipolar
impact on
multipolar.
So there is several things which are not visible before. There is several things which are not visible. Mines and minerals are there. So if mines and minerals are there. The spinal cord of economy should have happened later. There are many arrangements made later. So many arrangements made later, which would have happened. So which did not come in the reckoning of the court for good reasons. Which did not come in the reckoning of the court for good reasons. While the court, I think that will be an important factor. The mining sector is the important factor. The mining sector is the impact from nanotechnology to healthcare. From nanotechnology to healthcare. And in my notes, just only 2 paragraphs. And in my notes, just only 2 paragraphs. Lots will just make it in volume 2M. It's in volume 2M. Paragraphs 2, 3, 4, and 5. Paragraphs 2, 3, 4, and 5.
Attorney General on a lighter side, I've not done what I should have done. On a lighter side, I've not done what I should have done. Just trust me. I should have mentioned a little booklet of your aphorism. I should have mentioned a little booklet of your aphorism. Multipolar impact is what I've now got. Multipolar impact is what I've now got. From nanotechnology to healthcare.
The latest judgment is your worship, the Chief Justice judgment, yesterday's judgment
That
is
they
your
do
worship, the
maintain
Chief
their own
Justice
little
judgment,
dice. That they do maintain their own little dice.
Yesterday's judgment is the Bar Council case, Lord. Yesterday's judgment is the Bar Council case.
Bar Council case is
Only saying, the Lordships have said, yesterday, the Lordships have said, yesterday, Bar respect of some other case.
The word which catch my attention was, the word which my attention was, conferred upon the highest court of the country, conferred upon the highest court of the country, only, and the test is, and the judicial statement, and the test is, when you know that economy will be impacted, when you know that economy will be impacted.
Finally turn to easier and 182. I would read 182 has all the first point is we fully endorse the Solicitor General. First point is we fully endorse the Solicitor General. Second is that my submission is your Lordship will not make it state. My submission is your Lordship will not make it state hiding prospective overruling or not. Your Lordship is hiding prospective overruling or not. The acts will follow. No refund at that side. Subject to no refund. What I have done is perhaps stating the obvious, but what I have done is perhaps stating the obvious. Some your Lordships have held repeatedly. First thing is India Cement. First thing is India Cement, but India Cement, not only India Cement, India Cement is para 35, 36. First is India Cement. Prospective overruling in the mining area. Prospective overruling in the mining area. Mentioned. Para 89. Second is synthetic in my note, which is in your 89 page. These are in my note, which is in your bunch page 182. Third is Belsun. 182 onwards. These judges. Third is no refund, no recovery. These judges. Same no refund, no recovery. Sugar is all the constitution benches 9 judges. All the constitution benches 9 in para Belsun 112. In para Belsun 112 and 113. Belsun is 1999, yes, 9 SCC, 1999, 9 SCC, and the relevant paras are 112 and 113. And the relevant paras are 112 and 113. Synthetics, my lord knows it, 89 para number. Synthetics, my lord knows India 89, 35, 36. Yes, in India Cement is 35, 36. Interesting judgment is Somaiya Organics, Constitution. Interesting judgment is Somaiya Organics, Constitution. 2001, yes.
And you got the
2001,
para 27, 5 SCC,
519,
para 27.
Para 27. 519. Para 27. Yeah, the crux I've underlined it para 27. Now crux I've underlined it para 27. Now in commercial mind that your lordships have innumerable high courts and tribunals in the country following India high courts and tribunals in the country following India Cements in a much lesser context. in a much lesser context, Bhatia and Balco, the hiatus between the arbitration and Balco, it's only about 5 or 7 years. The arbitration field, it's only about 5 or 7 years. 10 years. 10 years? In that context, fellas, in para 197, the citation of in para 197, the citation of Balco 2012, 9 SCC, Constitution 552, made it more prospective than even asked for. It said arbitration agreements entered into after this date.
Malad, I just wanted to add something. Malad, I just wanted to add something. Malad, I wanted to add something. Malad, I want not to cite any judges. And I promise not to cite any judges.
Can we just get back? Can we just get back? Yes,
as we always say sometimes, the reason is not people plan their affairs. The reason is not people plan their affairs. Just to add to the width of the canvas. Just to add to the width of the canvas. Not entirely where this canvas are operating. Not entirely that I'm not anything other than what suggested. Anything other than what no payments to suggested. I.e., no payments to recoveries. And no recoveries. Situation as prevails today will prevail. Situation as prevails today will prevail. Just to underscore the need for this. Just to underscore the need for this kind of. One of the petitioners before your lordship an example. One of the petitioners before your lordship. Manadi, the history is these lands were acquired. The history is by the lands were acquired. These are coal bearing from the states. These are coal bearing. These lands were acquired. They were challenged. The Supreme Court. These lands were acquired. They were challenged. The Supreme Court upheld the acquisition of land for 19. And then the problem arose. The government said you are not paying us. The problem arose. The government said you are not paying us anything. You payment is fixed under the law in lieu of payment is fixed under the law in lieu of complex arrangement between the state. And this is a complex arrangement between the state of how this mineral wealth is to be shared. Of how this mineral wealth is to be shared. Then, my lord, in 2004, Orissa government came. Then, my lord, in 2004, Orissa government came. The High Court following India Cement struck it down. High Court following India Cement struck it down. Whether it's true or not, struck it down. But the fact is, it relied on India Cement. The fact is, it relied on India Cement. And today, my lord, if this company is asked to, and today, my lord, if this company is asked to talking in excess, it is talking about in excess 1,000 crores to this one company. 56,000 crores to this one company. These are not national companies. They have sold their coal. These are not national companies. They have sold their coal to power generating companies. As the solicitors told power generating companies. Sold water into the bridge. Sold water into the bridge. So if this company, and this company, the other consequence which concerns, in some of these companies. Demand will be multiple times their net worth. The bankruptcy law doesn't apply. Public sector undertakings. These are public sector undertakings. You will have the ugly spectacle of these companies. Just going belly up. If the governments insist they attach their properties, if the governments insist they attach their salaries, they won't be able to pay salaries. They will not.
Thank you, Mr.
Only to paint the canvas how white the canvas. Only to paint the canvas how white the canvas is. And that is why, my lord, certainty.
2 minutes, my lord. I made a note. Taking the cue from Justice Roy, I given 8 reasons why the cue from Justice Roy, I given 8 reasons why it should be prospective, my lord. Yes. My lord, most important thing is, my lord, this. My lord, most important the nuance approach. I've got a paper by the Ministry of Mines. I've said in the aftermath of India Cements, which said in the aftermath of India substantial revenues. Several states in 1991-92. And then in 1991-92, deeply increased the central government, the Section 9 royalty and the dead rent. To compensate the royalty and the loss of revenue they would have suffered because of India. For the loss of revenue they would have suffered because of India. The royalties have been substantially increased. The royalties have been substantially increased. Even today, my lord, when I pay Section 9 royalty, even today, my lord, when I pay Section 9 royalty in Tamil Nadu, levy by the center, it goes straight to the state. It's a levy by the center, it Ministry of Mines report also. So I have given that where Ministry of Mines government was compelled to steeply increase. Central government was compelled to Section 9A levies. Section 9 and Section 9A levy for the loss of revenue. To compensate the states for the loss of revenue. Secondly, my lord, I have given in my chart. I've given in my chart, right from 11 judges, Golaknath, just 10 cases, right from 11 judges, Golaknath. Every time there's a tectonic shift in the law, every time there's a tectonic shift in the law, a provision which is or the court is upsetting a provision which is there for 20-30 years, whether Golaknath or Indira Sani or whether Golaknath or in chemicals, they are given 10 judgments covering and chemicals, they are given 10 judgments covering mining law, arbitration law, tax, mining law, arbitration law, uniform practice is there, and Golaknath Justice Subbarao uniform practice is there, and Golaknath Justice Subbarao puts it sitting in a bench of 9. He says your lordship down the law. In a bench of 9. Lays down the law. Make that law applied for the future. You because you want to apply it for the future transition. Because you want to ensure a smooth transition are not affected. Lordship, I've given the note for Tara 49. Are not affected. Very nice. I've given the note for Tara 49. Subbarao. Very nice. The entire law in the U.S. Subbarao. He discusses the entire map of the Ohio and Linklet, etc. Map of Ohio and Linklet, etc. So that's the sunburst doctrine. The other point I wanted to mention is one important point now. The other point I wanted to mention is one important point now. I read the judgment in detail. I think there is a comprehensive first time, my lord, I think there is a interplay between entries in list 1 on the interplay between entries in list 1 and entries 49, 54 and entries 49 in list 2 for the first time. 54 in list 2 for the first time. But in fact, on a serious note, I just told him we have to rework entire Schedule 7 I just told him we have to rework entire Schedule 7 now. Thanks to your lordship.
Mr. Data wrote a letter to me, seeking to be senior advocates designation committee from the senior advocates that with my book coming up, I have no time for anything else. With my book coming up, I have no time for anything else. You might have to extend that sojourn away from the court for a little longer. Postpone the I'm ready to postpone the on a serious note, lordship has really not considered the interplay of various things. Has really not considered the interplay of various things. Now, most important thing is. Now, most important laws were held to be legislatively incompetent. These laws were India Cement legislates have no competence. India Cement states have no competence. Now your lordships are restoring competence. 24 for the first time in so from 1990 to 2024. So from 1990 to 2024, and whatever it does, Kesaram cannot override India. Whatever it does, very clear. Cannot override. We should not send a wrong message. Very clear. We should not send a wrong message that tomorrow a 9-judge bench nuancing it and that applies. 7 is 7, it has to be followed. And that applies. 7 is 7, it has to be followed. Tamil Nadu they followed, didn't make any new law. My lord, Sundaramaya's case is important now, my lord. My lord, Sundaramaya's case is important now, my lord. Yes. My lord, the Orissa Act is 2005, Jharkhand was struck down, West Bengal was 2005, Jharkhand was struck down, West Bengal was Sundaramaya's case they say, etc. Now, in Sundaramaya's for legislative competence, if a law does not revive for legislative competence, it does not revive. He makes two distinctions: law struck down for constitutional prohibition, law struck down for legislative competence, and law struck down for legislative competence. If it is struck down for legislative competence, says that it will not revive; it has to be reenacted. It will not revive; it has to be reenacted. Now, states will necessarily. That's the reason why it has to be prospect. Now, because the 2005 law was based on India Cements and other laws. Because the 2005 law was based on India Cements and other laws. Now, your lordship judgment holds the field. Very important. Your lordship is completely It's very important. Your lordship is constitutional topography of all these entries. How to interpret constitutional topography of all these entries. How to interplay both and so on and so forth. Sundaramaya. So I'm only submitting prudent for the states to make a fresh law keeping in mind states to make a fresh law keeping in mind. But only I'm only saying that we have to be conscious of that. But only I'm only saying that we have to be conscious of that fact.
That is on the principle. The law is on the principle. The law is struck down. The law is struck down judicially. It cannot be revived judicially. And it cannot be revived judicially. What has been struck down goes as voice.
Our academic then our academic then
That's exactly the point in the Article 39.
Exactly, my lord. Therefore, my lord, I was also avoiding that argument. Therefore, my lord, I was more an academic argument in this matter for an academic limited purpose. This matter for this limited purpose.
I assume, my lord, is in the Bombay exact matter. Yes, you decide. But this judgment, you decide. Holds, my lord, that this judgment, dead and buried.
my lord, that what is dead and buried not being there on account cannot be revived. Competence not will have to be afresh. Cannot be revived. If it has to be fresh, it has to be today. If it has to be fresh, it has to be today.
But not the issue right now. Not the issue right now.
Not
the issue.
The
The lordships have reserved the judgment. We have assessed. The lordships have reserved the judgment. We have assessed.
Only one thing I want to add. Only one thing I want to add. Only one thing. Lord, only one thing as a matter of. Lord, only one thing as a matter of. Lord, as a.
That's okay as a point also.
Lord, as a.
That's okay as a point also.
We are saying that it is because something we are saying that supply. It is because something supply.
All right, let's hear now.
One idea, Lordship.
All right, let's hear now.
One idea, Lordship, was enacted on 1 Odisha Act was enacted on 1/2/2005. Odisha Act not that day was enacted and Odisha Act on 1 was enacted and became operative on 1. It was struck down, my lord. It was struck down, my lord, on 5th of December.
Let's not go statewise.
5th of December.
Let's not
On
go
5th
statewise.
of December 2005. On 5th of December 2005. There were no demands. For 6-7 months, there were no demands. There were no demands. And no demands under that unconstitutional. And now being sought to be revised. Now this is Odisha's now being sought to be revised. Some states' position may be Milord hybrid. Some states' position may be Milord hybrid. Some ways not to go Milord into this. Therefore, it is best not to go Milord. Some states will say, we were Milord. Some states will say where some money was paid. Milord, somebody will say where some money was paid. Somebody will say so. Let's not Milord apply this water refund. The Lordship's judgment is for the whole apply this principle. Therefore, Lordship's judgment is for the whole country. Therefore,
any interim order security for the bank deposit.
Not for Odisha, there are in not for Odisha, there are in some cases, there is an order of deposit.
Only one line, my lord. Academically, only one line, my lord. Academically, I have compiled line, my lord. I have compiled.
The reason for, I'm only requesting, the reason can subject to all lordships approval. The problem we constantly face. Why judgment declares the law and constantly face. Why judgment declares the law. There is no direction it will be prospective. But there is no important direction it will be prospective. The arbitration is important case. Like for example, lordship said by the law. That necessarily has to go back. Lordship said by the law. That necessarily has to go back. Lordship is completely rewriting the problem.
Not only one line, my lord. Only one line. Not only one line, my lord. Only one line. Lord, only one line. Lord, we have compiled only one line. 63 judgments where your lordships have consistently. 63 judgments where your lordships have consistently prospective overruling, which is annexure A to my note, which is already filed, and annexure A to my note, which is already filed and circulated.
With the paragraph, with the extract, annexure A, lordship just sees my, so lordship need not go through all the bills.
Yes.
Lordship need not go through all the bills.
Yes. Yes, Mr. Dutta.
I think the learned advocate general of Odisha wants to say something. Learned advocate general of Odisha wants to say something before I.
We have a very specific, we have a very specific.
Just give me 1 second. Yes.
Does your lordship knows, this Odisha Act knows, this Odisha Act is welfare measures in tune with the Odisha's welfare measures. Mostly this mining bearing areas, population mostly these mining bearing areas are 9 districts as the schedule area. 9 districts, so the as the schedule area. Socio-economic development of the state was of paramount. Development of the state was of paramount. 2004 enactment was made by the legislature. 2004 enactment. The rule was framed in 2005. So the rule was framed in 2005. I have prepared a small CZFD notes. I have prepared a small CZFD notes which I may pass over. That this while implementing the provisions of the rules, while implementing the provisions of the subsequent, we have to keep in mind by way of subsequent developments by way of some ad valorem royalty amendment, some ad valorem royalty. That is correct. That is from 1 to 2005, that is correct. And 12 2005. That's right. Absolutely. 2005. That's right. Absolutely. There was after the legislation, there was after the legislation was struck down. It was struck down following India. Right. It was struck down after that because there was no interim order. So after that, so we could not proceed further. So it is as so we could not proceed further. Now subsequent laws have been enacted. Now subsequent laws have been enacted. MMDR Act Amendment 2015, MMDR Act Amendment imposed. These are the four 5 bullet points. These are the four have been instructed. 5 bullet points which. So while implementing this rule, while implementing this rule, we have to keep 2005 subsequent developments in mind, certain like introduction of ad valorem rate of royalty, introduction of ad valorem rate of royalty since 13th of August 2009. This is the so I have to. This is introduction of auction for allocation because introduction of auction for allocation because royalties since 13th August 2000. Royalties since 13th August 2000. Second is introduction of auction for allocation. Second is introduction of auction for allocation. 2015 amendments, that is and this is auction premium is an additional payment. And this is auction premium is an additional payment also. Introduction of provision for collection of the introduction of provision for collection of the DMF. This is mineral for the taking of these social welfare measures. Taking of these social welfare measures.
Look, these are collections over and above Section 9. These are collections over and above Section 9. So, we are not really concerned with this one. But if we go state-wise on the lighter side, on the lighter side, state-wise, Madhya Pradesh and Rajasthan, I had a state-wise Madhya Pradesh and Rajasthan, I had that we have taken a pro-citizen approach. They are also supporting the citizen approach. They are also supporting the prospective. But that has been not the state economic fourth is introduction of provision for collection of payment of national mineral exploration, national mineral exploration. Two funds which will be basically the purpose will be utilized for the benefaction of the utilized for the benefaction of the.
How much did you realize? Estimate
that we have
how much did you realize royalty?
That we have
ad valorem royalty premium which then as a result paid for after 2000 which then the DMF paid national mineral exploration.
That I have to work out because that data I have to work out because calculation is not yet made because that calculation is not yet made because I have to provide further instruction for that. So, but the legislation was basically meant for that. The legislation was basically meant for that, for the socio-economic development of basically the schedule areas of the society. Basically, these are the four specific. So these are the four specific.
Then of the state of Odisha that all falls without being made prospective. What is the bottom line? Falls without being made prospective. What is the bottom line?
We have to basically work out. Bottom line is we have to basically work out. Because the rule is what would be the total implication because the rule is
supporting the plea for prospective route. You're not supporting the plea for prospective route.
If I say prospective, it would be a burden. If I say prospective, it would be a burden. Staker would be on our staker. Staker would be the economy of the state is in shambles now. We have economy of the state is in shambles now. We have socio-economic development for the socio-economic development.
What are the instructions about the correct stand you should be taking for the about the correct stand that you should be taking for the post? Decide on that.
Exactly, they have not stand. I have to work out. And I have to work out.
You have to lay bare your first 4 points which you referred to. Your first 4 points which you referred to. Realize something more thanks to the amendment. Realize something more thanks to the amendment. 9 scheduled tribe districts, etc. 9 scheduled tribe districts, etc. Implement the judges as it stands. Don't implement the judges as it stands. Where do you really So now within these two, where do you really, both the submissions, one on this side, one on this side. Both the submissions, one on this side, one on this side.
Don't
pass on your dilemma to the court. Don't pass on your dilemma to the court.
I have
You will decide what to do ultimately. You will decide, but what to do ultimately will hold the balance. But
I have
you have to tell us where you
because
stand.
this judgment is epoch making. Now it has cascading effects everywhere. Now it has cascading effects everywhere. So I am not going into that in detail for the time being. So I am not going into that in detail for the time being.
But are you supporting that or you not supporting? You have to tell us. Now that you are appearing, we'll
Now
hold you
the
down
scenario
to
has changed in Orissa. Now the scenario has
be
contradictory stands. There can be
So,
contradictory stands.
This is not
therefore,
what the
this is not what the
I have
are you flowing with the
I have to protect my exchequer. I have to protect my exchequer.
Everyone is protecting everyone's exchequer. The question is protecting everyone's exchequer. The question is whether being shared by the common man, ultimately being shared by the common man or not. That's all. Should be acceptable or not. That's all.
Common man should not pay to suffer because of common man should not pay to suffer because